Good afternoon, everyone. Chris Gantt-Sorenson with Gantt-Sorenson Boyd here. Glad to be here talking with you about interactive process. And I'm going to encourage you, particularly in this situation, that you send as many questions that you have in the chat or the Q&A box. I think the best way for us to approach interactive process today is actually to have an interactive discussion. And so send me obviously questions you have, examples you want to ask about, and Raven is going to read them and ask me those, and we can talk about them, just as long as we always understand that what we're talking about here today cannot be advice and counsel, because I don't know all the facts and such. So I'm going to speak more generally in response to any sort of specific fact situations you provide, but it can't be considered advice and counsel. But I've got great slides and we'll go through them. However, I want you really to ask me the questions that you have. Here's why we are doing this presentation. So many clients still are struggling with what is expected in the law about interactive process. And I continue to see ADA situations, which, by the way, I get calls on those all the time. And I'm sure you guys also deal with those all of the time. And the documentation, when employers are doing everything right, is not showing up the way it needs to. And often the interactive discussion itself is being misunderstood, and that's not being done right. And yet you're all out there trying to comply with this. So you have a good faith intention, but you're never going to get the credit for having a good faith intention with the EEOC or the law. It just, the rules are the rules and they have to be followed. So I'm hoping that today you come away with a better understanding of what is actually legally required for interactive process in order to protect the company. And I have a very comprehensive PowerPoint slide that you can look through later as a resource. And as always, we're glad to answer questions. I would say in this area particularly, ask more questions early before you're documenting anything. Ask questions as soon as possible in regards to any sort of medical question you're getting when we're having to deal with the ADA, so that we can help process and prepare what you need to have in writing, so that we can avoid liability and investigations and all sorts of tedious issues later. So with that being said, I'm talking about the questions, and also, as usual, remember, we have a pretty comprehensive team. We've got folks in Columbia, we've got folks in Greenville, a good depth team at this point. So we ought to always be able to jump on and help you on this. So the EEOC defines ADA accommodation, and this will be true under job description, job modification or leave, as any change in the workplace and the way things are done that enables an individual with disability to enjoy equal employment opportunities. And what the EEOC means by this is, if it's not done that way, if there are, there's set rules about how things should be done or set policies about how leave should be, that the EEOC out of the box is going to expect an employer to do something out of the box that's not done outside of policies if it can, and it's not an undue hardship. So you have some stops that you can ask about. For instance, are there limitations, restrictions of somebody who's got a medical condition right now interfering with their ability to do the essential functions of the job? That's the first stop. And that's something we talk about always when we're looking at this. And depending on what the doctor's limitations and restrictions are, it's up to the employer to decide, this limitation and restriction is going to prohibit them from doing this part of their essential function of their job. In those scenarios, this is not a qualified individual with a disability. Doesn't sound great on the paper, but it's the law. And we don't want to be writing stuff like that to our employees, but we are wanting to explain to them, hey, this is an essential job function. Your provider says you can't do this. Your provider says there's a restriction or limitation that you can't lift this much, or you can't carry this much, or you can't sit at the computer for however long. And that's an essential function of your job. And therefore, we're not able to accommodate. We don't have to necessarily say in that scenario, it's because you're not a qualified individual with a disability, but that is the first stop. And then the second stop is, if it's not going to impact an essential function of the job with or without accommodation, then we're getting into, medical documentations and requests of those sorts. So interactive process is discussions with the employee all the way through this. We're talking to them about, hey, you know, your essential functions of the job are this, and you see your restrictions say this, you know, we see this as you can't do the essential functions of the job. What do you think? How do you think it could be done? Do you agree that if you can't lift 30 pounds? Do you agree that if you can't sit at the desk all day? Do you agree that if you can only work 2 hours and this is a medical office and, you know, you are a medical tech, do you think, can you do the essential function of the job? And we're having that discussion, right? And it's getting documented. If we know that it's not an essential function and we're talking about undue hardship, that's the same thing. And we're talking to the employee. So, and we're having to discuss all types of things about what we can and cannot do. So I'm going to go through that a little bit more detailed, but that's what it looks like under the context of the ADA expectations of the EOC. ADA, always remember, is case by case on an individual. So it's depending on the specific individual who's asking for an accommodation, whether it be leave or modification. And it's also their specific job and what the job requires. And then it's also, what is the climate right now? Are we in a busy season or are we in a slow season? You have to evaluate it in the context of the individual, their job, and the circumstances. Who can cover the job, who can't cover the job. This is tedious. This requires you to spend a lot of time on one particular request that you've gotten or a situation where you realize ADA is applied. Most of you don't have time for this. This is the truth. Most of you don't have time for this. I think that probably very few employers have time to do interactive process in the manner in which the EOC thinks you should. And that's frustrating. And I have a lot of empathy for you on that. That's an area where we can actually help you, but you're going to still need to be the one that's going through the process. And whether we're helping you with it or not, this is what has to be followed. So, you know, we've helped clients come up with a form that helps them identify what the need is, the employees involving in writing on this form, and then, you know, discussions about what types of communications were. And as long as you're actually communicating with the employee and then that's being completed, and, you know, maybe we would prefer the employee signs this in addition to you, that is going to be a way to maybe move the ball a little faster, and it's going to also meet your documentation. But you want to be very careful. We're not looking like a checklist, and we're not looking like, you know, you just wrote it all in there and this is what we decided and we communicated to them. You need to also have proof that you have communicated this with the employee, and it has to be proof that you had a discussion. So, but maybe a form makes this quicker, and that's going to depend on more your workplace and the specific type of form you need. Katie Busby did one recently for a client, and she's a great resource for maybe helping you create one of those. The other thing, oh, no, sorry, Raven, pop back. Thanks. The other thing is you've got to be able to show you had meaningful communication with the employee and that it's documented. So meaningful means you had a discussion with the employee. Y'all talked about ideas. You talked about the restrictions. You talked about what are other ideas for accommodation if we can't do this. As far as leave, you know, how long do you think you'll be done? You know, what is it that you need from us? Is there any other thing that you think you could do with these restrictions? What you're doing, whether you think there's any reason to have a discussion or not, because you already know the answer, and you probably do already know the answer, you're having a conversation and letting the employee weigh in. I'm going to tell you, I think that's probably not a bad idea, because then the employee's not surprised by anything. The employee's been involved in the communication. Even if the answer is no, we cannot accommodate, whether it be leave or job modification, then at least they've been involved in the discussion and they've participated in it. They may not like the decision, but you can show that you've had this discussion with them, and maybe they'll be calmer about it and less apt to file a charge. Next slide. So what is the interactive process? Under the law, the interactive process is a collaborative, good faith dialogue between an employer and an employee or an applicant with a disability to identify effective, reasonable accommodations. It's a discussion. You know, I keep saying that. Dialogue is just simply, we need to be talking to the employee. And it's the employee and the employer. It's not a one-sided communication from us to them. Sometimes employers communicate entirely with employees by email. Sometimes employees prefer that. Sometimes employees who are out on leave or who are needing some sort of accommodation need to communicate by email. Sometimes they're anticipating there's going to be an opportunity for them to make a claim and they want it all documented. That helps us. All of that helps us. We want it documented. So if you need to communicate an email, then this is going to be a discussion back and forth in email, not a telling, not a this is the way it is, but question marks at the end of the sentence. So think about having a discussion by email if you end up having to only do this by email, and what it would look like, not conclusions, but discussions. And that can take a long time too. The other thing is, if it is a verbal discussion, then I want you to follow up with an email and say, thanks so much for talking with me. We discussed this and this today, and your comments were this, mine were this. You're summarizing it, you're paraphrasing it. And then you end with, please let me know if this is not, if I've missed anything, or if this is how you've understood the process. Look, and ideally, we're going to want them to reply back. They may or may not, but we can produce this communication, these email communications, and show that we've had this discussion. So virtual is another great tool too, and a lot of employers use that. And so record it. Depends on where you are, what state you're in. You may have to have consent to the employee to record it. Generally, you do need to have consent to record likeness of your employees as just a policy if they're going to end up in some sort of picture of any sort that the employer has. So maybe you already have that from them. But in this situation, if you're in a state that is a 2 consent state, South Carolina is a 1 consent state, then you're going to need to make sure that they're consenting to this. I know on Zoom, if a recording starts and you're not the organizer of the Zoom, the employee or the person on the other side typically has to click, you understand this is recording. So that may be a setting that you set. I don't know. IT and Keely and Raven take care of all of that for me. So I don't know if that's something you have to set, but do make sure in a 2-state rule that a recording is going to be agreed upon by the employee, or else you won't even be able to use it as evidence. And that's the whole reason I'm wanting you to have one. The discussion may take several rounds. I talked about that. Keely says it's a setting in Zoom. See, I don't know what I'd do without them. So several rounds, and that's why I gave the example earlier, and we'll go through that more, but it can't be a one and done. In most situations, this is not going to be a one and done. And as I said, and you're going to see that a lot from me today and hear it a lot from me today, but I'm beating a drum because this is an area where I don't see compliance, is every discussion must be documented fully. And we'll talk about what I mean by that. Next slide. Okay. This is what's not the interactive process. A decision made with no communication with the employee. And by that, I mean not the end result. I mean no communication through the process, or a one-sided communication with the employee by the employer. Discussion with the employee and input from the employee is key. And that's got to be documented, or else it didn't happen. We can't deny the accommodation with no discussion with the employee. This is true with or without explanation as to why it was denied. So if you explain in an email, we denied it because of this, that is not a discussion with the employee. You have to, if you cannot, what is not the interactive process is stating the accommodation is an undue hardship without explaining the reasons why, or failing to engage in the process, or delays in the process. So if you have someone that has a disability that says they're not able to do the essential job functions or the job, or that they need leave as an accommodation, you really should not be delaying. It's particularly in a job modification issue, really, or a leave issue. If they're coming to you and they're saying, I have this physical condition that is going to interfere with my ability to do my job, and we're going to require them to get documentation and that sort of thing, we have to ask ourselves, do we need to have them not come to work while we're going through this process, which of course means they're using their paid leave. ADA is unpaid. And we need to ask them, do you think you are able to stay and do the job? If we let them stay and do the job, and we have them being accommodated before we've even decided whether an accommodation is necessary, that's not a great idea, because then why couldn't we continue to accommodate? So you really need to think through, do we allow them to continue working? They've just said they can't do the job safely. Or is there something else that we need to do if we don't want to ask them to go home? But do think about that. Leave would be another one. We had a situation recently where this employee, and these employees, they can be very difficult. Y'all know this. I mean, I'm telling you something that you want to scream at me about, you know it so well. And, they say, yes, I want to stay at work because I don't want to use my leave, but I can't do this. And then later they'll criticize you for it. They'll criticize that it went 15 days, it went 30 days, and it took forever for them to get back to me after I'd given them their medical documentation that they wanted, and they had me working the whole time. It wasn't safe. And really, it's not. It not only on the ADA standpoint of we made them still work and we didn't take their request for modification or leave or whatever it was they wanted seriously, but you might end up having a workers' comp claim. So you have to think about evaluating that. And when in doubt, say, all right, you've said this isn't safe. We respect that. We're not going to want you performing it. There's nothing really we can have you do. So we want you to go ahead and get this paperwork to us. But for the meantime, just stay home and use your paid leave. That will probably make them be quicker with you about getting the paperwork back. Speaking of, that's usually a 7-day process unless you need to go longer with that. So next slide. All right, so let's talk about triggers. When are we triggered that, ooh, we might need to have an interactive discussion? So if an employee says, I'm having a little difficulty doing my job, we are now triggered. That's a trigger. I am going to have surgery, but it's no big deal. But I think I'll be fine, and I'll be out this day, but then I'll be back. If you have any inkling of any medical condition or psychological condition that is going on with your employee or an applicant, that is your trigger to know that you need to start having this conversation. And depending on what they're saying they can't do is what the conversation is. If it's, I think, I'm gonna have the surgery, I'm gonna need to be out a little bit, or I don't think it'll be long, we're talking about FMLA first. And then if they don't have FMLA, we're talking about ADA leave. If they say, I need an exception to this rule because I have got, this rule is that we have to report to work by such and such time, and I've got a condition that's making that hard for me, and I need to be able to come in a little bit later. I just want to be 30 minutes late. And we're like, oh, easy, we can grant that. Nope. Follow the process and say, all right, you know what, hear you about this. We need you to get medical documentation for it. And then go through the process with them and document it. I've had employers just grant leave or grant accommodations, modifications, all sorts of things. And because they had no problem with it, they just did it and they didn't have it documented. And so when the employee complained later that they were never given accommodations, they couldn't prove it. So you have to think about both sides of that. So anything can be an accommodation when they're asking for exceptions to a rule, a policy, to be out. I can't meet this one requirement. I can't do this. I need additional leave. And that's going to even be true with discipline. If we're sitting down to discipline someone and we say, you have not been doing this job well, this, and this, or you're not following this policy, or you're coming to work and you're being very emotional and aggressive right now, and you're causing a disruption in the workplace, or you're violating our intimidation or threat policies, however you mean it. And they say, well, the problem is I've been having these medical conditions. We're triggered there too. So it doesn't mean you can't follow up with the discipline at all, especially if you've got documentation of the discipline before this happens. That is ideal. If you don't have documentation of this before it happens, you probably have to go a little slower and be a little more careful. But in a situation, whether you have documentation or not, we are going to give the employee an opportunity to get documentation and us consider whether or not we should grant this exception to the rule, policy, or requirement. And we may know at the outset it's not going to be possible to do that, but we've got to go through this process. And we may ultimately decide we can do it. So we want to have documentation of all of us, of all of these steps that we're going through, even in a discipline situation. I will also say to you, there are some exceptions to that rule. If you've got documentation and they were going to be terminated, and the documentation is good, i.e., 3 or more instances that are documented in the last 6 months, I still want you to get legal advice, but you're in a far better shape there to go ahead and proceed with termination in that scenario, despite the disability. So I just mentioned that. Documentation needs to look like that. And when I say documentation, that's going to be proof that it was told to the employee signed that they were told this, or a witness in the room signed and said they refused to sign that they were told this, but this is what they were told. So that's the type of documentation we're talking about. In other words, proof that we can show it was told to the employee. So, but they're not required to say anything specific. They're not required to say, I've seen employers say, nobody asked for leave. They didn't ask for FMLA leave. They didn't ask for leave. They didn't ask for an accommodation. Well, that's not really required. under FMLA, under ADA, we're always expected as employers to anticipate, oh, this person has brought up medical. This person has brought up, they need an exception. We need to get into the discussion with them about why. If they're not talking medical or psychological, then we are asking why. We're not necessarily saying, oh, well, Chris said we're supposed to ask about medical condition. So we're just going to ask, do you have a medical condition? Do you need an accommodation? Because could be turned on you too. We just ask why. So, and we can, if they tell us there is a situation or they do need leave, we can ask for what. All right, next slide. Another trigger, I'm having difficulty. I need a modification in my job. I need leave. A trigger that I see that's missed a lot is the employee's unable to return from FMLA leave. So at the outset, let's say we've gotten an FMLA medical certification and the employee's provider has said this employee needs to be out 17 weeks. And we all know FMLA is only for 12 weeks. And so at the end of it, we just send off an end of employment that you weren't able to return and your FMLA leave expired and you're terminated. That's going to violate ADA. We are required towards the end of the 12 weeks to reach back out to the employee and say, hey, has there been any change in your condition? Are you able to return? Give us an update on your status. In this scenario, I always say, get medical documentation, get medical documentation. There's going to be some exceptions to that. So, and always on a case-by-case basis too. So take this in a general context. But in this scenario, we already have something from the provider that says this employee can't work for 17 weeks. So we could just take the employee's word for it, that when we communicate with them at the end of 12 or, shortly before the end of 12, and they say, no, we still can't return. We're going to be out this, and this long. Then in that scenario, maybe we don't require them to go get medical documentation. We take their word for it. But we are engaging in the interactive process with them. So ideally, you're going to need that in communication, in writing from the employee. If this is a verbal conversation and the employee is not going to send it to you in writing, then you're going to send it back to the employee. Thanks for speaking to me on this day and confirming that you're not able to return to work. Then that's where we begin the leave as an accommodation analysis. Can we grant it for the extra 5 weeks that they were going to be out for? If we can't, then we need to have this discussion about undue hardship. And are there any alternatives? If you've got current restrictions, maybe the restrictions are different now and they could do some other available position with the restrictions, but not their own. So these are types of things you have to think about. And you also have to discuss with the employee and explain to them and be able to prove that you explained it to them. So an employee says to you, another trigger is, I'm not able to do this specific task. I have pregnant restrictions. I have temporary restrictions. This is a process that triggers the ADA. And in this scenario, we're going to ask the employee to communicate the nature of the problem, the rule, the policy, and how it impacts their need for an accommodation. Next slide. More triggers. What you don't want to be in the legal position, excuse me, of having to do is to explain, well, the employee didn't ask for an accommodation. I didn't have a discussion with them about what the problem was. So you have all the knowledge, just like FMLA, when a situation could potentially trigger an ADA request or FMLA. And as the HR or the employer, you have the absolute right to ask, why do you need if they don't tell you, why do you need this? What do you need? And have them explain to you what they need and have discussions with them about it before you go forward. Next slide. All right, so step one, somebody has come to us and they've made a statement that makes us think ADA is triggered. We ask them for the reason for the job modification. What is the accommodation that's requested? If it's leave, is it sporadic? Is it temporary? Is it taken in a block? And when do we think the need for modification or leave will end? So we're having this discussion with them. If it's verbal, we need to write the answers down to this and have the employee sign. I mean, anything we can do that has the employee sign and date is even better. But if not, then you're writing this all down and you write that this was reviewed and this was what the employee said, and you sign it and date it. All right, next slide. Okay, so now if it is something that we know we need medical documentation for. And by the way, I'm a fan of being very consistent with every single employee. So there'll be very few instances when I think we don't need medical documentation. I know I just discussed one on the FMLA. And that kind of depends on the situation. But as a general rule, I'm wanting you to follow the same process. So we tell them, okay, great. Thanks for talking to me about it, what you thought you needed as an accommodation and your ideas. And we'll get back to that. But right now, I'm going to need you to provide medical documentation of the need for the accommodation. And this documentation really needs to be a form that the employee has their employer, their provider, sorry, fill out. And you need to send the job description with the form. And if you don't have a form, we can help you devise one. That's something that we do for clients. But also, you can say to the employee, these are the things I need to know. I need to know if you have a condition, how it impacts you doing the essential functions of the job, and can you do them with or without an accommodation? And I want the doctor to tell us what your restrictions and limitations are and how long they're going to be for. And if there's any medications that you're needing to take that are going to interfere with your ability to do the essential functions of the job. So this is, of course, why we have to also send the job description. You give the employee 7 days to return. There might be situations where you need to be more considerate and give them longer. In this scenario, there can't be enough said about the importance of, number one, looking very supportive of the employee, not holding to strict, fast rules of, nope, it was 7 days. Don't think in terms of technical. Sometimes I think HR can be very technical, and and I don't mean y'all as individuals, I mean just doing HR. Certainly benefits is very technical. Pay, very technical. Don't bring a technical mind to this sort of murky area of the law. Our communications want to be supportive, not promising anything, and where we need to, granting extensions. So we say 7 days, and at the 7th day at 5 o'clock, they haven't gotten it to you. We're firing off a letter. Well, your accommodation is denied. You didn't do it. So we just need to be a little more gentle. And our communications, even if we are following these pretty strict rules, they need to be gentle. They need to say, hey, didn't hear from you. Today was the deadline. So I'm going to assume that you no longer need the accommodation, and, we'll see you back at work on such and such day. If they reply back, oh, no, I did need to get it. Okay, we're going to evaluate what are we going to do about that and how are we going to handle it. I think that's a good area where you get some advice if you haven't already. Because I do think I'm going to tell you my advice often depends on the specific situation. And we're talking about what their personnel file looks like. We're talking about what the actual situation is. We're talking about, is this someone who has a mental health condition? Is this someone if they've not been able to get in their doctor, they're not able to provide it. So don't just be very technical in the communications here or the response here or in how we write it. Always look compassionate in writing on these matters, and generally, but particularly these matters. Next slide. Okay. Here I am saying again, please be consistent about medical documentation. The reason I want you to do that is later on, the employee may say, well, you denied mine because I didn't have the right medical documentation, but I know for a fact that you didn't make Johnny do this. So exceptions to not asking for medical documentation. If they're obvious. Now, I pulled this specifically from the EOC, where it says both the disability and the need for reasonable accommodation are obvious. I don't actually agree with this, and the reason why. That makes you, the HR, me, the person that's trying to talk to this employee about this, the doctor and the understander of the accommodations that are needed. And honestly, you could see someone that had obvious disability and obvious reason for accommodation, but now you're stuck. Well, let me say this in a more compassionate. Now you're left with taking the employee's word for it about exactly what they need, and who knows what they add in, right? So I am not a fan with this. I want us to ask every time. I want us to ask every time. I want us to know what the restrictions and limitations are so that we can decide if there are things that we can grant. And I do see employees coming to employers and just saying, I need this and this, and we do it like they're pregnant or there's something else that is obvious. And later on, I'm looking through it and going, well, I wonder if this was really an accommodation that they needed or it's just something they wanted. So I'm not a fan of it, but I have to put it in here because it's in the EEOC documents. And so clearly that's maybe something they expect. I can't imagine the EOC would get upset with employers for following the medical documentation process every single time. I've never seen that happen. I can't say they wouldn't though. So there are instances where they've already provided sufficient information about the disability and the accommodation needed. And so maybe you don't need the documentation there. Those situations that I think of, or if they're also filing for short-term disability at the same time, or it's a workers' compensation claim that is ongoing and you have medical information. You know, comp, you're getting medical information, and sometimes comp and ADA are running side by side. So if you've already got medical information and it tells you what the restrictions and limitations are, then in that scenario, I don't think it's the right thing to do to send the employee back to the doctor. When I'm talking about accommodation in this instance, this is an area where I'm not actually referring to direct threat. Direct threat's a different scenario where we're sending them to the doctor. And there are different rules about how we might handle that in that scenario. Doesn't mean we're not still wanting the medical documentation. We need it. In fact, with direct threat, we have to have it. But just note that if you're in a direct threat ADA situation, rather than accommodation, the process is a tad different about how we're handling them going to the doctor. We're having to pay them for it. For example, we're having to reimburse them their mileage. And we have to work with them for as long as it takes them to get into our doctor. So that's just kind of an overview. I'm sure there's other things. The other thing that is true that I don't see happen a lot is you can actually request information from the provider to determine whether or not, or the employee, to determine whether or not the requested extension will result in an undue hardship. So the things I can think of that might come up like that are, how long is this going to be? Is it going to be temporary, or is it going to be sporadic? Is it going to be some days not? Things like that, medication, those sorts of things would apply to that too. For instance, they have to be on medication for a period of time that might interfere with their ability to do some of the essential functions of the job. And that would be an undue hardship for us to grant the accommodation for that period of time. So those are things you can ask. And it's kind of hard to analyze when this might apply, but keep it in mind when you're going through a specific situation. Next step, slide. Next slide, please. Oh, okay. Inviting the supervisor. So you are going to have to consult with the supervisor. Ideally, HR is dealing with this entire process, especially at the first part of it where we're talking about medical and documentation and such. But at some point, once these restrictions come back, once the information from the provider comes back, you are going to have to consult with the supervisor, because the supervisor is the one who knows the job, is going to be able to tell you whether the essential functions with or without accommodation can be done, whether the restrictions are going to interfere with it, and also undue hardship. So you're going to have to talk to the supervisor. In this situation, you're really not supposed to tell the supervisor what the condition is and what the restrictions are. Typically, you're only supposed to talk about that an accommodation was made. I don't see really how you can do this without talking about what the restrictions would be. And so I think you'll just have to play that on a case-by-case basis. But the less that the supervisor is told about the condition and what is needed, the better. And you shouldn't have to tell the supervisor what the condition is for any reason, even if you do have to talk about restrictions and limitations. You also may want to invite the supervisor to the second step. The second phase this is where we engage in the accommodation discussion once we've gotten the medical documentation back. You may want to invite them into the room to talk about that with the employee. Because here we are again, we're having this interactive discussion about, here are your restrictions, limitations. This is these are the types of things that are essential functions that it doesn't seem like you're going to be able to do with these. How is it that, you think that'll work? Or if they're not essential functions, they can do the job. If the doc says that maybe they can do the job, then we're saying, all right, so these are your restrictions, but we're not sure how you're going to be able to do the job. Can you tell us how you think you're going to be able to do the job? The supervisor is a great person to have in this discussion because they know the job. What I want you to do is talk to your supervisor alone first and have these discussions. And then if they go well, have the supervisor come with you. You're already going to know enough about the supervisor. You may decide it's better for you to do it by yourself. So that's going to be a decision that you have to think about. What we're trying to avoid is that the supervisor is having any discussion with the employee that is going to create liability or cause us concern. And they don't know the ADA. They don't know what you can and can't say. Most supervisors don't to employees. You do. And so protect this discussion to the way that you think it needs to be protected. All right, next slide.
Hey, Chris, before we continue to the next slide, we have 2 questions in the Q&A.
Great, ask, and it gives me a chance to take some water.
So the first one is, if we receive a doctor's note for an employee that has work restrictions, do they need to submit an ADA request for accommodation for the work restrictions and the employer go through the interactive process?
Okay. Well, I'm going to look at that one. I read it one more time while I look at it. Is it
If
in
we
Q&A? There we go. Yeah, because that seemed, yes. So read it one more time and I'm gonna look at it.
if we receive a doctor's note for an employee that has work restrictions, do they need to submit an ADA request for accommodation for their work restrictions and the employer go through the interactive process?
Okay, so in this scenario, I think what you're saying is we already know we have a doctor's note and it has work restrictions. And you're saying, does the employee actually need to submit an ADA request for accommodations? No. In that scenario, they have already done that, in my opinion. You've received a doctor's note for an employee that has work restrictions. Now, if you're saying you've gotten this from workers' comp, then you do want to talk to the employee if you think they need a modification or leave or what have you. So, and you want to document it if you're having this discussion because you are having an ADA discussion. But I wouldn't understand why we would need to ask them to request an accommodation if we have a doctor's note from them that has work restrictions. I think in that scenario, you think in the terms look more globally of workers' compensation. Let's say the doctor's note came in and it's not a comp one. You're coming to the employee and saying, all right, you've got these restrictions. So what is it that you need? You know, you can sort of, I love questions because especially if they're being documented by somebody, you're asking them, they're writing down your questions and they're writing down the employee's responses. We've got these restrictions and I thank you for providing them. What is it that you need? What do you think we should do about these? Try to get them to have a discussion with you about, well, I think it's going to be a problem for me to do this, this, and this, and this, and this. But we don't have to be a formal, you need to request an accommodation because already we're on notice that they might need one. We're just wanting to approach it in a way that we try to get them to tell you what they need. If they don't tell you anything, then you're looking at these restrictions, and it really kind of is also your obligation to decide, okay, I think with them having these restrictions, I don't think they're going to be able to do the job. I had a situation once where an employee notified her employer that she was pregnant and she worked around chemicals, and the supervisor was concerned because they knew that these chemicals could harm fetuses. And so the employer notified HR and said, what do I do? You know, in that scenario, we're wanting to sit down and say, hey, you know, you indicated you were pregnant. Congratulations, that's great. A little bit worried about you around these chemicals. That's a direct threat, right? We're in a direct threat situation. But you could also do this for an accommodation situation where you're saying, hey, you know, this restriction says you can't lift 30 pounds and you can't lift more than 5 pounds, and you know your job requires that. I think we should probably talk about this. And so I think that gets you into the discussion that you're needing to have safely, legally, I mean, and permits you to document that they're making an accommodation request, whether they intend it or not. So don't think technically. Don't think we didn't get a request for accommodation. Think more, this employee has told me about these restrictions, whether they've set them or given me a restriction. You're now triggered. I've got to have an interactive process. All right. I think I answered that. I hope I did. All right. So let's do the next one.
All right, the next one is, if there is a recently hired pregnant employee who is not covered under FMLA, are they covered under ADA?
That's a fabulous question. I'm so glad you asked it. Yes, they are. If I'm not entitled to FMLA leave, I am always entitled to ADA leave from day one. Day one. So you have to go through the process. And that is, if they meet all of the requirements, you have to grant the leave, assuming it's not an undue hardship. So those are great questions.
All right, this next one is a multi-part question.
Okay.
When you have an employee that is out for a medical condition, how much are we allowed to ask about? To what extent should we know what the employee is dealing with? We have an employee now that does not want to disclose any details regarding her condition. She is out on unpaid leave and is content doing that for now.
Yeah, so that is a really great question. Um, an employer is always allowed to ask, why are you out? And they have to tell you, I'm out because of whatever. If they say, I'm out for a medical condition and I don't want to tell you, then we say, all right, we need you to have your provider complete this form. We need you to, we need you to have your provider review your job description and send us your restrictions and limitations and how long you're going to be out. You absolutely can do that, even if they've not told you the medical condition. They cannot just say, I need to be out and I can't tell you why. That is not going to fly. That's a no. But if they say medical condition, psychological condition, that's when we say, all right, we'll consider leave as an accommodation for you. But you need to provide us with the medical documentation for it. We want to know what I just said, restrictions, blah, blah, blah. And you've got 7 days to get it back to us. Will that be a difficulty? Yes, it's a difficulty. Okay, you've got 10 days. If we don't hear from you in 10 days, we'll not be able to consider the accommodation. So that's what we do. You are allowed, you say, to what extent should we know what the employee is dealing with? You're allowed to know exactly what the employee is dealing with, whether you actually know the condition or not, because you need to know restrictions and limitations. You need to know how long they are. You need to know if they're on medication that prohibits them from doing the essential functions of the job. And the only way we can know that is getting something from the provider. So it's a great question. And then unpaid leave. That's another thing. A lot of folks say, well, they took unpaid leave, so, what am I going to do? If you're an exempt employee and you have accrued PTO, they can't, I'm putting on the FLSA hat really fast with y'all, Fair Labor Standards Act. They can't take unpaid leave if they have PTO because the employer may end up being the one liable for wage claims in that scenario. So if someone has PTO, I'm wanting an employer to always require them to use their PTO. I really am. I know y'all may have situations where you don't want to do that or what have you. And so I know I'm speaking very generally and not understanding those, but from a FLSA standpoint, I am always wanting you to run any sort of absence with PTO. And if it's a vacation and sick leave instead of PTO, then, and it's sick leave, do the sick leave first and then start using the vacation. So that's just something I want to mention. So, all right, I'm getting a little thumbs up, and I don't know if that means Heidi's like, okay, Chris, you're talking past the close. I do tend to do that. Yeah, so I definitely think you've got to have those discussions, and people can't just be out on leave and not tell you. I think if that hasn't answered it, put something in the chat again. All right, Raven, what's the next one?
Next one is how much should a manager's willingness to allow the requested accommodation influence the organization's role in the interactive process?
So that's a great question. And HR, as you know, you are the keeper of consistency. And so this is going to be true with discipline. And y'all can look, this is why I love it when HR has to review any sort of reviews or discipline situations, because you know what the company's doing across the board. Well, that's going to also be true with these accommodations. So the managers get involved with their employees. I am involved with my employees, right? So, I mean, this is just you become friends or they've worked with you for years, and somebody comes to you as a manager and they say, I need this accommodation. Well, that manager wants to grant it, they grant it. Somebody else they've not worked with as long, don't like. I mean, the managers are humans, right? Well, no, I don't know. You're gonna have to go to HR. Well, guess what? We now have an ADA discrimination claim because one person was made to get medical documentation and go through the process and the other wasn't. And this person has a comparator and they'll be able to prove absent some sort of defense, but generally they're going to be able to prove that they were treated differently because of their disability or on the basis of their disability and the other person wasn't. And there's actually an EEOC example to that effect where somebody that had a psychological issue in her department and she took it to the manager or HR and they required her to get medical documentation when other people with physical issues in the department had been granted it. And that was liable, that the company was held liable. So consistency is important because you can keep the manager from making decisions that are manager specific or employee specific. That's not what we mean by case by case. We mean case by case by, do we grant the accommodation and is there a way we can do it? Not if they want to grant the accommodation. I hope that makes sense. So you need to happen to that process. And the manager actually needs to be kept out of the medical process because the manager makes decisions about employees that impact their it can be adverse employment actions or promotions, hiring, firing, changes of duties. And so we want to keep them as isolated from any knowledge of the basis of a medical condition so that we can also contend later that no, it wasn't the medical condition. It was you were doing your job or some fill in the blank, you had a violent outburst at work because HR dealt with this. The manager was not involved in that and they didn't know about it. So that's actually also another reason why you have to do the process without the manager handling it, but you handle it instead. They just want you to grant the accommodation. You want to be able to show that you were the decision maker about whether or not the accommodation was granted. And that again helps with any sort of adverse employment action that becomes later. If the decision maker was not the manager, and now the manager is the one who's deciding to terminate someone for something, that's actually a legal offense. So I can think of every reason in the world why we should not allow the manager to make the decisions on the basis of this. I hope that answered the question. I got kind of rambly. What's the next one?
All right. What if the employee is seeing multiple healthcare providers to rule out a diagnosis? How long should we allow employees to return a confirmed diagnosis?
That's a great question. And so another one would be if we're getting different different forms from different providers, which has happened. So somebody trying to rule something out, okay, remember we're case by case basis. I don't know how long you go. I think it's going to depend on what the reasons are. So we have the 7-day thing, and I want you to say 7 days initially, and I want you to do that in writing. And then if they say, no, we need more, I want us to ask them, well, how much more and why? And then we decide, all right, well, we grant it. And if it's reasonable enough, I would. But after about 14 days, then we probably could be a little more discerning about, are we going to continue to grant? And it's going to depend on what the excuse is. If it really is that the doctor's out of town and this is the doctor I have to go to, I mean, maybe we do. It's interesting though, because this whole time, is the employee out? Are they out of leave? Are they out of unpaid leave? I will say, here's another area where if we make them use their paid leave, they'll tend to get the forms back to you quicker. Another reason to make them do that. So I think it's case by case basis, but at some point, don't go so long, right? At some point, if we're now 20 days, I think we sort of have to say, all right, that, you're really going to need to get this back to us. I'm not a fan of going past 10 to 14 days to where we're saying you're going to have to get something back to us. But I know with some providers, there's some pretty, if they're at like a specialist or something, they may not be able to get information from the specialist that they need. In most settings, though, they ought to be able to get a note if they're needing, they don't want to come back and do something and they don't want to come back to work. They're most likely going to be able to get a note from their own internist or some place that says they need to be out until this can be resolved. All right. Are there more questions, Raven?
Yes, we've got three more. Do you want to go ahead and answer those or
Yeah,
get started?
absolutely. I told Raven before this, I said, let's do whatever questions are coming instead of the slides, because you'll have the slides. I have a lot of information in the slides for you later. And I really felt like it was good to have an interactive discussion on an interactive process, no pun intended. And so if we don't finish the slides, but we're talking about questions, I'd rather us be doing that. So thank you, Raven.
So our next question is, what if the doctor's note needs additional information included?
That's a great question. There's specific rules. I know I'm going to say this about FMLA right now, and you're like, Chris, we're here about ADA, but there are specific rules about how you ask for additional information under the FMLA. And so please understand there's regulations about it. Authentication and clarification are the regulations, and it tells you the specific process. Under FMLA, you first tell the employee, hey, this FMLA medical certification, it's not clear, we're going to need more information. You let them go and you say, we need you to go and ask the provider for it. And then they come back and they've either provided it or not, but you can keep having them do that. If they don't do it, then there's another process that you can follow, and we can talk about that. And then the other thing is you can ask for clarification. That's the clarification standard where you're saying, this doesn't make quite, it's vague, and we need to know more about this. Can you go back and ask your provider? And then authentication. And authentication is when you can actually communicate with the provider's office and authenticate that this is the doctor's signature or that this was provided. Never communicate with the provider's office about anybody's condition. Actually, sometimes, and this is going to slide back into the ADA world as well, the providers or the people in the office will tell you all kinds of things. Tell them, hey, yeah, I don't, I can't know that. I just needed to know, is this the doctor's signature? Is this the doctor's signature? Those providers' employees are violating HIPAA, and that's their problem. But ADA confidentiality is your problem, and you don't need them telling you about an employee's condition. Under the ADA, if I need additional documentation, it's the same thing. We would say, you know, this is not as comprehensive as we need. We need the restrictions. I'll tell you a great example where this comes up is the doctor writes down the accommodations that the employee needs. This happens a lot in remote work. The doctor does not write down what this person's restrictions and limitations are. They just say, this employee needs remote work as an accommodation, or this employee needs to only work 4 hours a day as an accommodation. And they're talking about accommodations. Well, that's the employer's province, not the doctor's. So in that scenario, we send the employee back and we say, you need your doctor to tell us the restrictions and limitations.
All right, next question. I have an employee that has refused to complete FMLA paperwork. I am assuming that I need to grant ADA accommodations to his intermittent leave.
Um, no, that we're going to deny the FMLA and say you have not provided us with medical documentation. And then we need medical documentation to consider an ADA accommodation. So you have to go through the process.
If we are a full, sorry, Chris.
Yep, go ahead.
If we are a fully on-site company, do we have to grant an accommodation to work remotely if that's the accommodation that works best for the employee?
I think that's a great question. And I will say, absent undue hardship, yes. So ADA is you change the way things are normally done. And even though you don't permit remote work, you would have to consider it. Number one, can the employee perform the essential functions of the job with or without an accommodation by working remotely? And look, a lot of times they can't. What if they're a quality manager that are supposed to inspect everything that comes across the conveyor belt or that goes out? Yeah, how can they do that remotely? What if they're a security personnel and they're supposed to maintain security in the facility or help evacuate in situations like that? So let's talk, don't forget to look at essential functions once you've gotten this medical documentation about restrictions and limitations. And then if we've gone through that and we see that, it's not going to interfere with essential functions, then we have to only consider it under undue hardship. In that scenario, here's some things I want you to do if you ultimately decide you have to grant remote. You want to say it's temporary. You want to say that this is only in this scenario and that they are required to still perform the job well. And if they're not doing it, it's going to have to be revoked. And then you're going to want them to sign a remote work agreement about returning the computers and showing up at work when it's necessary for meetings, or because you can require that. Like somebody wants remote work, their doc says it's best for them to have remote work. You've decided that the restrictions suggest that's true. Then you can still require them to come to the office for certain instances to bring the computer back to have it updated or whatever you need the computer back for, or for meetings. And so you have those discussions. All right, we can grant this, but there's going to be these weekly meetings. They're going to say, well, I want to attend virtually. Look, that's pretty difficult to do when everybody else is there in person. Well, having done this certain times where everybody is in the room and I'm attending virtually, it doesn't work very well. So ask just, why is it, can you come in just this day? You can go through all types of questions and kind of pattern out how it's going to be granted, then you need to document that.
A lot of people tend to make jokes like, it's my anxiety, it's my OCD, it's my ADHD. How do you go about this, slash, where is the fine line between a joke and seriousness related to the ADA?
Yeah, that's a great question. Um, if they're saying it to HR, then say, oh, are you asking me for something specifically? Or are you just making a joke? I'd just go ahead and do it. I think I'd just do that every time. And you might train your supervisors in management training to say, hey, if someone says stuff like this and they're asking for a change in how they do something, you need to send them to me. So great question. I am going to ask that we pop down to the documentation slide because I want to do a couple more slides just to be sure we finish some of the, oh, wait, go back up one, go back to interactive process, step 3. All right. Just remember to make sure you're doing step 3 and that we're going through this process, asking them their ideas of what accommodations they want, asking them if that won't work, what other accommodations, brainstorm together to come up with ideas. And think in mind, you as HR and or the supervisor have to come to this discussion with an open mind of how to do things differently. And if the accommodation is one you can grant, then we are granting it, but we're documenting the plan and the employees assigning. Next slide. This is documentation that you have to do. They're dating and signing it and saying, yes, this is what the accommodation was, and we're all signing it. Next slide. When it cannot be granted, you have to talk about alternative accommodations that may be granted in the same process. What do you have? This is an idea. We have this. An employer does not have to grant the accommodation that's requested, but they do have to grant alternative accommodations if they can, and if they cannot, they have to be able to explain why undue hardship is for any other any alternative accommodations. This gives you some ideas about questions that you can ask the employee when you're doing the accommodation analysis, interactive process, and you don't think you can grant it. Do you think you can do the job? What about this requirement? And if you have somebody who's taking notes and they agree, I can't do the job, you're right, I won't be able to do this if I can't lift 30 pounds. Your scribe has just written this down. All right, let's slide to documentation slide. Documentation with the employee. So after the conclusion of the process, you're having the employee sign what y'all agreed upon. All through the process, though, I want to be clear about this, you're also documenting your discussions. If there are expectations about follow-up, make sure you're putting this in the documentation with the employee. We're granting the accommodation for this period of time, and then we need to revisit. Always put in that the accommodation is temporary. If you don't, then at some point it might slide into a job modification that you have to grant permanently. That can happen even with FMLA if you're trying to do an alternative job or you've given them sporadic leave for a position, and then all of a sudden, like there's a specific instance where the Department of Labor said this accommodation that was given to the employee they moved into an alternative job or they changed their job. They gave them a reduced job schedule. They worked 6 hours a day rather than 8 hours a day. And then after the FMLA period was expired, the Department of Labor and the EEOC said, oh, well, if you did it for that long, you can keep doing it as a job modification accommodation. They still only have to work 6 hours. So just make sure that whatever you're writing up, this is temporary. We're going to revisit. If there's no end date for the accommodation, we're going to revisit. This is temporary. If the job isn't getting done, we'll have to revisit. Put some protection in for you. Next slide. Documentation for HR file. This is what I'm not seeing, or I'm seeing, but it's not as thorough. Every single conversation has to be documented. Ideally, that means having someone with you that's taking notes of everything you're saying and the employee saying, and that person is dating and signing the notes. Again, we talked about virtually and how to do that. We've talked about emails and how to do that, but you want to have every discussion documented with this employee. This isn't intended for the employee. It is intended for when there is an ADA lawsuit, ADA EEOC charge about accommodation brought. Those are increasing. I am seeing those exponentially more than I used to. And others have, others in this field, including investigators, have indicated to me that that's also true. If you don't have documentation of these communications or that you engaged in discussions, good faith discussions with these employees, asking them questions, coming up with ideas, brainstorming, all that stuff that's in my slides, then it didn't happen. If you say, well, we talked about it, and then when I sent them a note and said, this is why we had to deny it, it didn't happen. None of it happened. So I'm going to leave you with that. You have a very comprehensive set of slides, and I'll answer any remaining questions and that are out there. And For those that need to go, I understand you need to go, but for those who want to stay and listen to the rest of the questions and answers, great.
Next question. If you grant an accommodation to permit remote work as a result of the ADA process, but other employees in similar positions are required to be in the office, and those employees question why that one employee can work from home, how do you respond?
I think you just say there's been a specific instance that this is needed to be done for. It's not our policy. It's an exception to the policy. And that is why. You can't tell them why. Certainly, you can't say this is for a medical reason or have any discussion like that. And granted, we're not necessarily violating a confidentiality rule by saying what the medical reason is. But if we're saying there's a medical reason or a psychological reason, then we're going too far in what we're sharing. And we've now just told the other employees this person has a medical or psychological condition. So we just have to say this is an unusual situation and it's an exception that we've granted. And typically, I bet you there's not going to be many situations where it's a permanent change, right? And so you can say this is temporary. And pretty much there's always the quip too, although you're HR and I know you're supposed to be nicer than a lawyer is about HR. I'm an HR lawyer, I'm not an HR. You can say, look, why things are happening with other employees is personal to the employees. And just like I don't share your information, I don't share theirs. So that's another thing to say. But of course, employees are going to feel that way. They're going to feel frustrated. They want to work remotely too. So I think you do have to anticipate those. That's a great question.
Legally, when can you terminate someone who is not complying with the requests for documentation and it continues to drag out, causing undue hardship for the employer?
Fabulous question. The EEOC says there are two instances where an employer does not have to consider accommodation or grant an accommodation. It's in regards to leave, by the way. This is specifically in regards to leave, not modification. One is if the employee refuses to get the medical documentation. And so we talk about drag out. What that looks like is we've given them 7 days, they don't get it back. This is why I want all this in writing, even if you have no problem initially granting this. You've got 7 days. And then they come back and they say, I need more than 7 days. Why? So then they say, I need 3 more days. I need 5 more days. You evaluate, are you going to do it? I do think you grant it, especially depending on what the circumstance is. I haven't gone to the doctor. I haven't tried, but we probably don't grant it there. But in most situations, they're going to say, I haven't been able to get to my doctor, what have you. Okay, we're going to grant it. So we're going to give them 10 days. And we put that in writing, or we document the discussion that we had with them. Somebody's taking notes, the same thing. Or we follow up in writing. Okay, nice to speak with you on such and such. You said you won't be able to get it in 7, so we're going to give you 10. Let's say now we're at 14. And that communication where we're going to give them 3 more days, they've come back and said, I can't get it in 10. Here's where we're going to say, you indicated you still can't get it. The deadline to provide this is going to be 14. At that point, we're not going to be able to consider your accommodation request. So make sure you get it to us by day 14. And you give them a time even. Of course, if you give somebody a time and they're an abuser or a player, they're going to, of course, send it to you a little bit later in the day. So sometimes I think it's better if we just don't say a time, nor do we apply a time. We just say, you got to get it to us by the 14th. And then let's see what happens. And on the 15th, if they haven't provided, then we say, all right, you haven't provided it. We've given you 3 extensions or 2 extensions, however many extensions to do it. So we're going to have to go ahead and deny your accommodation because you haven't provided us with the medical documentation that we requested. So that's how that goes. The other exception is when the employee's doctor has said this person has to have indefinite leave. And if it's indefinite leave, that is going to be an undue hardship typically. I will tell you, we still have to be careful about that and think about it on a case-by-case basis. But as a general rule, indefinite leave, you're not going to have to grant the leave because it's an undue hardship. In that scenario, if it's indefinite, I think you need to have a communication with the employee of, hey, it's indefinite. And under the ADA, indefinite leave is undue hardship, automatic undue hardship for the employer. So, we're probably going to have to deny the accommodation and give the employee an opportunity to go back to their doctor to put a deadline on it. I know you don't maybe want to do that, but I think that's better legally in the end if we do that.
Who do you recommend bringing in as a witness for documentation as an HR department of one?
Such a good question. So if you don't have an administrative HR assistant that can come and do this, of course, that's ideal where they're taking the notes. Then in that scenario, you're inviting, sometimes the supervisor comes. Sometimes it's just somebody at that level or higher, that comes, that's a director or a manager, and one of you, somebody else is taking the notes. So don't invite anybody's peers, of course. So I think that's the easiest way I can answer that right now, but make sure that it's somebody appropriate that's coming in if you don't have an assistant that can do it.
Is it necessary to involve anyone else, such as payroll, general counsel, or a member of the organizational hierarchy, regardless of employee's role?
I think that's typically going to be what that's going to be per company. So what does your company require? I will say if you've got general counsel, I absolutely would consult with general counsel. They may choose to be participatory in it or not. I don't know, but I know I'd be consulting my general counsel about this. And then from there, you just need to follow what your company policy is.
Not related to the previous question, hypothetically speaking, if an employee supervisor is concerned about fit for duty while the employee's healthcare provider is determining the right dosage of prescriptions due to anxiety, etc., how do we handle a fit for duty concern?
Okay, so the manager you said, or is concerned about fit for duty, that's where we get into ADA direct threat. Those are rare situations, and it simply means that an employee is going to either be potentially harming themselves or others if they continue in their job. In that scenario, a direct threat process is a completely different process, and that might be something we probably need to talk offline. Um, but you can have that employee go out and get medical information, same documentation from their provider, taking the job description, and you have the discussion that's going to be documented. Hey, we're really concerned. You're passing out on the floor, and you drive the forklift. Here's an example. And we're pretty worried about you continuing to do that, and we don't want you to come to harm. And so at this point, we're going to need you to go to your doctor and have your doctor review this and give us your restrictions and limitations. And in that scenario, what I'm wanting to write, what I'm writing, if I'm writing your form, is on such and such date, the employee passed out on the floor. The employee advised they've passed out on the floor before this employee drives a forklift. Their job description is attached. I would like for you to fill out this documentation. And those questions look a little differently. They look a little different. But we're wanting the employee to go get some information from the provider, and we're not wanting the employee to continue working until or report back until that's provided. Once it comes back, or if the employee doesn't have a provider, then we're sending them to someone that we've identified as a provider that can do this, go through it. Any fitness for duty exam needs to be specific to the essential functions of the job, not just a normal exam, right? So you would have that provider that you've retained, make sure that they're determining whether the employee can do the essential functions of this job safely. So there's a lot more to direct threat. And honestly, I think that's would have to be a presentation for another day. And also something maybe that I would have to talk about for about 30 minutes right now. And so I probably won't do that, but I'm glad to help offline.
All right, and our last question for the day is, what are our obligations for recertifying requests? We typically approve on a 30, 60, or 90-day basis. And then she clarifies that she's talking about medical certifications.
Right, so this is FMLA. And if the doctor has said the employee is going to be out for 12 weeks, we should not be recertifying. We should just say it's 12 weeks. If the doctor has said something that suggests that it's okay for us to ask every 30 days, then we can. But if we already have a note that says the opposite, we should not be doing that. And as far as intermittent leave, there's no reason to ask for recertification except annually, and maybe not then. So those are the FMLA rules. One more thing, I don't know who else is still on, but be really careful about granting or letting people do light duty, because once you do it, it's the same thing. Now we've created an accommodation. So once you grant light duty for any employee while you're waiting on medical documentation, you're opening the door to having to do it all the time. So do be mindful of that. Any other questions, Raven?
Chris, she clarifies that she means for ADA, and she
Oh,
says, for example, remote work.
so I will say this, if you have a policy of 30, 60, 90 days, ADA requires exceptions to every policy. So my thought would be, don't have a policy. Instead, if someone has been given remote work for an accommodation, let it be case by case. How long did the doctor say they needed it? If it's indefinite, then remember, indefinite leave is not something that has to be considered. It's considered an undue hardship under the EEOC. So here I'm saying this, I'm not giving legal advice. There may be other scenarios or situations that I don't understand about as far as why you're doing that. But as a general rule, the EEOC says indefinite leave is not something that has to be granted. So if you're following up every 30, 60, 90 days, it's making me think there might be indefinite. I'd rather it look like the provider has said this person needs leave for this long, or this provider has these restrictions for this long, and therefore they need remote work. And if we're going to grant it and it's not an undue hardship, then in that scenario, we're following up 7 days before the end of that to ask, look forward to having you return to work. The restrictions were through this date. Let us know if there's any update. Otherwise, we'll see you on such and such day. And then that will prompt them to follow back up with you if they need more, and make them go through the more not recertification. I don't really want you calling it that, but just, all right, we're going to need more medical documentation of it, and go through the process again.
And that is all the questions.
All right, I really appreciate it. I hope that everybody will get a chance to look through the slides. They're very, very informative and very thorough. And I really appreciate everybody coming today. I think in May, we're going to have Denny speaking, and I'm not entirely sure what on, so look for our webinar in May. And then, of course, in June, we tend to do a mid-year update and maybe some other topics, but stay tuned. Thank you for coming today. And as always, we welcome any input that you have about what you want to hear. In fact, that's what I like to look through and see what that is. A lot of times that's what I'm talking to you about, is stuff you're asking to hear from us on. So have a great day. And Raven, thank you as always. And Keely.
Of course.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.